Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content. And today is the day I earned that subscription. For today's story, we are trying to catch up a little bit on the Critical K. The Critical K is a social commentator. They had a YouTube channel. I believe it's been since removed. And they were commenting online, and they fancy themselves a journalist. And they wanted to cover a case in the matter of Ray Andiachero. Ray's child died. The manner of death is somewhat in dispute. Some people say murder, some people say suicide. There is a bit of a dispute on the issue. And the mom has been a vocal advocate for several years in defense of her position on the whole issue. Well, Critical K over here, Karen Yaks, decided that she wanted to enter the fold of this story, true crime story. And she contacted people in the state of Mississippi for comment and relayed things and said things that could potentially be defamatory. So she was sued because, she said some things regarding the mom in terms of her behavior, her own behavior, the mom's behavior, in addition to things regarding her deceased child that were potentially problematic. So she got sued, and she has been representing herself in the great state of Mississippi, and it hasn't been going incredibly well. It hasn't been going especially well with her because we have reached a point of default. And she's been trying to avoid default not particularly well. So we're going to cover a couple documents that have been filed. These were filed in late October, early November. And I had forgotten that this happened, and then someone reminded me, you should cover this. And I'm like, you're right, we should. So let's go ahead and do that. We're going to cover a couple filings regarding this matter. All right. So first set of documents is from Karen Yaks, pro se, to the Southern District of Mississippi. She's being sued in federal court in regards to this matter. And here is what she has to say about the plaintiff, Ray Andiachero, wants sanctions and showing cause for failure to respond. Right? So we're moving basically for default. So we'd like sanctions. And part of that is relating to failure to appear in conferences, failure to appear at scheduled meetings, failure to engage in discovery, basically failure to participate in the process. That is basically the root of this thing. All right. And so they have moved for, failure to participate in the things. And here is what Karen has to say in her defense. Consistent with findings in Twombly, Rule 8A2, the Supreme Court has made clear that stricter pleading standards shall apply to all civil actions in federal court. Well, that's kind of a little bit true. This goes to this idea of notice pleading, and let's get rid of the chat on screen since it's blocking my face, and that's not what we want at all. There, let's get rid of that. All right. So anyways, this is going to this idea about what's called notice pleading. In federal court and several state courts, you have notice pleading, which basically just means you have to put them on notice. Now, the federal system is slightly more strict than notice pleading, but not really. It's just notice pleading with a little bit of teeth, right? Basically, you just can't say complete bullshit. You have to actually show something, like anything at all, right? You just have to make out the barest bones of your prima facie case. Like, for example, you want to allege defamation. How would you go about doing that? Well, like, for example, here's a statement they made, right? Here are the statements they made. These are defamatory, right? So it's the barest bones of the barest bones. But it's basically, in strict notice pleading, all we do is we say, we're suing you for defamation. Right? And we don't say anything more. The federal courts have amplified this very slightly. So yes, it is stricter than notice pleading, but not by much. Anyways, so it shall apply to all civil actions in federal court. When the plaintiff gets close to stating a claim, but without some further factual enhancement, it stops short of the line between possibility and plausibility of indictment for relief. Again, yes, a little bit stricter than notice pleading, but not much. We have to show more than the mere possibility, right? The mere possibility is not enough. It has to like make some sort of sense, right? This is kind of like proof beyond a reasonable doubt territory, like the inverse of that. We have to show a thing. Anything at all would be fine. So that it's merely possible is not going to work. You have to show it has some possibility, but basically any real possibility at all. Mere conjecture, in other words, mere speculation, in other words, is not going to do it. Speculation, conjecture, theory, conclusory, not going to do it. But any facts at all basically will get you past the line. All right. In keeping with this, the Supreme Court has further expressed concern with the cost and expense of discovery on a baseless claim, stating that when allegations in the complaint, however true, could not raise a claim of entitlement to relief, the basic deficiency should be exposed at the point of minimum expenditure of time and money by the parties. Yeah, that makes sense, right? If your case is flawed, we should throw it out as early as possible, right? So fair enough. We are going to chide the federal judges, as we should, that to the extent possible, we should dismiss things sooner rather than later, right? Let's not waste time. Let's not waste time and money. Fine. Twombly's standard was also involved in the intangible value of ensuring that citizens such as defendant, who are unlucky enough to be named in meritorious lawsuits, shall receive meaningful vindication. The plaintiff shall bear cost of that vindication. Yes, if it were truly meritless, yes. As a sanction, yes, but I don't think we're quite in frivolous territory. Yeah. Whatever can be said for plaintiff's claims, we're not. We're not on the baseless, frivolous, meritless. Can they win? Well, if it were properly defended, who knows? But since Karen Yax herself seems to be giving it a go, yes, they can. It is with these sentiments that defendant, as an out-of-state resident living in Michigan, who has not waived her right in challenging the constitutionality of being subjected to litigation in an unfamiliar foreign jurisdiction to which defendant has never even had a passing familiarity with the form of Mississippi and the overall weakness of plaintiff's meritless claims of defamation. All right. Defendant respectfully argues the court erred in denial of the motion to appear for a mediation conference. All right, so let's talk about this. All right, so what she's alluding to is the idea of personal jurisdiction, right? We've talked about this a lot. We talked about this, for example, in the Without a Crystal Ball case versus Toddy, right? One of the problems there when we were trying to sue Without a Crystal Ball was that Without a Crystal Ball didn't do anything in Washington. This was the problem, right? This was the problem. She didn't do anything in Washington. She never went to Washington. She never targeted her videos really specifically at Washington. She didn't talk about Washington. She didn't call sources in Washington, right? She didn't do anything in Washington. And to the extent she did a thing in Washington, it wasn't enough things, right? We need some basic minimum contacts, right? Sufficient minimum contacts in federal court, right? This is going as deep into it as you like in terms of personal jurisdiction, right? You need to do enough stuff. Now, one of the things that can be enough stuff is if you do the thing in the jurisdiction. That is enough stuff. So, for example, although you wouldn't be in federal court for it, but the example will still hold. Like if you get in a car accident in a place, like even if you have no other contacts with the place, the car accident occurred there, right? So that is like the basis of the thing, right? If you go and punch someone in the face in a place, right? Even if you have no other contacts with the place, that's sufficient because the action itself occurred in the jurisdiction, right? If you commit a crime somewhere, that's enough, right? So what Without a Crystal Ball had going for her in the Toddy case, and where the judge ultimately came down, I think correctly, was she didn't do anything there. She didn't do anything in Washington. The problem with Karen Yax is, well, arguably she did a thing in Mississippi. She may not have visited there, but that's not necessary, right, to commit a tort, particularly in today's days and age. What did she do? Well, among other things, she called sources in Mississippi, it seems, allegedly. She called people in Mississippi, and she said things to these people in Mississippi, right? So that's the thing, right? Now, you could still have an argument about the whole thing, right? You could still have an argument. That's not enough. It didn't really occur there. There's defenses to that. But plaintiff has an argument. It's like, well, you called someone in the state, you talked to them, you said a thing, the thing was false. It's like, well, that's an argument. Is it counterable? Possibly. Did Carignac counter it? Not even close. So that is why the distinction exists between her and Without a Crystal Ball, for example. So yeah, she may never have been to Mississippi, but she allegedly called someone in Mississippi, so that's a problem. And while calling them, spread lies, allegedly. So that's a problem. Defendant respectfully argues his court erred in denial of the motion to appear telephonically for mediation conference. Yeah, no. The court has already heard your motion to dismiss on the personal jurisdiction thing, and no. And, you got to kind of participate in the court process. So, no. Defendant raises two elements which serve as the basis for her defense. Okay. Defendant has been entirely self-represented as a reluctant pro se litigant while attempting to plead, respond, and navigate the confusing labyrinth of federal judicial system and foreign jurisdiction from out of state. Well, that's a good reason to hire a lawyer. You of course have the right to do it yourself, but and a court is likely to give you some mercy, but only so much, Yeah. Plaintiff repeatedly acts out of hostility, physical threats to her person from her brother online. What? Plaintiff's outrageous conduct and online harassment via proxies and leaking of these civil court proceedings. They're in the public record, man. It's on the record. I got this from Pacer. I downloaded it myself and everything. Okay. Her outright refusal to engage in private civil discourse has made it all but plain to defendant plaintiff is once again abusing the courts as a vexatious vehicle to economically harass and victimize the same ensemble of victims and further raise the burden of litigation against defendant. Well, if you're basically arguing anti-slap, then, maybe, although plaintiff has at least a plausible cause of action, right? I think what can be said is that plaintiff has passed the bare minimum threshold to get past go, right? That's a good way of put it, right? Because that's what we have to remember, the various standards at various places, right? So what are the various standards, right? And I talked to you a little bit about this in terms of federal notice pleading, or maybe it's notice pleading plus, but not very much, right? So like we can ask different questions at different times. Like, can plaintiff win in the end in a fully defended case? I don't know. I haven't thought that far ahead, right? Can we get to the end goal? I don't know. But has plaintiff made their burden for the complaints? Yeah, I think so. And the court is right as far as I'm concerned. It's like, yeah, you've made it past the bare minimum threshold to make it past boo. I can say that much. Yeah. And you're not doing a lot to prevent that from developing further, unfortunately. Although defendant does concede that by raising the issue regarding her lack of access to basic legal defense and counsel, she is raising a larger, fundamentally socio-economic and constitutional rights issue, which cannot be addressed or rectified by the civil court at this time. What? However, defendant's sole purpose in raising the issue of her pro se status is to serve the court with contextual facts surrounding the timeline of events, both retrospectively and concurrently over the duration of the suit. Okay. In similar light, defendant raises the issue in order to refute suggestions which have been repeatedly made by plaintiff that defendant does not take this court or petition filed against her seriously. It seems a little less than serious, particularly since you fail repeatedly to show up to court-ordered conferences. and participate in things. It is no secret defendant acting on her own behalf as a reluctant pro se litigant has invariably resulted in poorly worded pleadings, improper filing, potentially waived rights, and defenses among an entire litmus of other detrimental preliminary rights. I'd like to remind you at this point that this is Karen Yax herself writing, because that sounds like something that like the other side might say. Karen Yax has said, by me going pro se, it has resulted in my pleading sucking, them not being filed properly, me potentially waiving rights, and so forth and so on. I think Karen Yax might be giving a good reason why you might be advised to not go in alone and why you might want a lawyer. Because she's like, by doing this, I may have forfeited rights. Yeah, that's definitely possible. As a result of defendants' innumerably failed attempts at retaining even the most basic legal counsel, due in part on the multi-jurisdictional complexities of defending this case leading up to the telephone conference. Actually, there's not really multi-jurisdictional at this point. At this precise moment, it's only one jurisdiction, Mississippi. Because they're alleging acts in Mississippi. Mississippi law applies. So it's not really multi-jurisdictional. You may not live in Mississippi, but this is not really multi-jurisdictional. We're not trying to like cobble together claims from multiple places, as I understand it. Okay. So, and then we're going to see attached multiple appends on behalf of defendant to retain counsel or even the most basic legal guidance. She's had some problems. Incidentally, if you know, I will give the same advice I would give to anybody. You know, if you need a lawyer and you don't know otherwise how to get one, I would recommend calling your state bar association and your city's bar association. These are good places to start. So if you don't know where to find a lawyer, calling your state bar association and the city bar association, or more of the point, not your state, the state in which it's happening and the city in which it's happening is a good place to start. They can help you with referrals. And you can also try the web. And I've recommended avvo.com and Martindale Hubble as two online resources that are good in order to get a list of leads. And then from there, you'd probably want to go to their websites. You then want to interview at least a couple different lawyers to get a good sense of who works with you. Remember to do your own due diligence. This is generic advice that I would give to the world. So if you need a lawyer, your state bar association, your local bar association, and the internet can be your friend. But remember to do your own due diligence in the end. Great. All right. So that would be, and again, not your bar association, but the bar association of the place where the thing's happening. So there's some good generic advice for you that will soothe everyone well. It's not a bad place to start. Anyways, compounded by plaintiff, brother Chris Thompson, and counsel and witnesses listed in initial disclosures, Renee Doughty Barefoot, Misty Evans, Emily Harding, repeated malicious online posts and acts of online intimidation and manipulation prior to and leading up to both conferences. And then we're going to see some more attachments. The outrageous conduct of plaintiff and affiliates of plaintiff online and offline during the claim. I think Miss Yax is about to express some disappointment that people have not been praising her online. We will see together. Defendant was fearful, whether real or imagined. Unfortunately, the reasonable man test does always apply. So, yeah. That even appearing telephonically, she could be legally bullied or railroaded into conceding some sort of irreparable legal, financial, jurisdictional culpability by attending what she did not understand at the time was simply a case management conference. Well, that's a little bit on you. And yes, those things could happen. So your fear is not completely baseless because, yes, you might say a thing during the conference that might in some way bind you. This is possible. is one of the reasons, again, that you want a lawyer with some experience, because yes, what you say can and potentially will be used against you in a court of law. So, but that doesn't mean that you don't have the right to not participate. See, that's not an option, right? So yeah, it is possible that during this conference, you might say a thing that will in some way prejudice you. That fear, unfortunately, does not give you the right to not participate. It does give you the right and perhaps incentive to consider a lawyer. Okay. Also, another decent way to find lawyers, by the way, is contacting law schools in the jurisdiction in which you're being sued. Some of them have clinics. And again, while they probably won't, they will be in a position to maybe provide recommendations. So if you have a law school in your state that has a clinic, then you can call them and ask for recommendations. That's also a decent way to go about finding a lawyer. Remember to do your own due diligence on top of everything. Anyways, continuing on, defendant strongly contests the repeated assertion made by plaintiff that failing to attend the telephone conference, that writing a check to satisfy court sanctions levied against her is of no significant consequence. Well, it's supposed to be of significant consequence because we're trying to incentivize you to do the thing. And then if not, we're going to whack you across the head and be like, oh, that punishment hurts. That was kind of the idea. Simultaneously denying herself key opportunities to participate in the process of advocating for her own interests in some sort of preemptive strategic means in achieving an advantageous or even desirable outcome for defendant. Yeah, that is definitely what defendant is doing. I can assure you that is exactly what defendant is doing. Defendant is 100% trying to engage in preemptive and strategic means in achieving an advantageous or desirable outcome for defendant. I'm pretty sure that's happening. I'm pretty sure defendant and her lawyers are quite, yes, they are in the process of advocating for their own interests in a preemptive, strategic manner to achieve an advantageous or even desirable outcome for the defendant. I'm pretty sure all that is in fact occurring. In the alternative, it is defendant, not plaintiff, who has been significantly impacted, not only in the form of economic sanctions. Well, that's because defendant's the one that's not been playing nice with others, which only further compounds her economic disadvantage in relation to plaintiff. Maybe you should have not done those things. The penalties are meant to hurt so that you will do the thing. Right? This is somewhat equivalent to being like, oh man, I got busted for this crime. This jail time really, really sucks. Yeah, that's what we call general deterrence. It was meant to serve as a deterrent for you doing the things. Like, I would like to not go to jail because jail blows. Then, don't commit crimes. That's what we call general deterrence. Congratulations. Anyways, and also true in civil cases. Defendant has also forfeited her right. This is defendant themselves talking about themselves. Okay, so defendant is now arguing that defendant has forfeited their rights. That seems like a strange idea for defendant to argue, that I've forfeited my rights, but okay. Defendant has also forfeited her right to participate in the case management process by including, but not limited to, objecting to plaintiff's overly burdensome discovery requests, denying herself opportunity to give equal input in the case management deadlines or regarding dispositive motions. I recommend against just openly confessing in the middle of your own pleadings. It's not necessarily the greatest legal strategy. Okay. Nevertheless, defendant does accept responsibility for her failure to attend telephone conference last year. Okay. Defendant did promptly pay economic sanctions. Defendant did immediately comply with all related discovery materials, interrogatories, answers to the best of her ability and capability. Defendant did immediately rectify her clerical mistakes. That is, ensuring she submitted concise, properly headed, and legible materials and signed with certificates of service. Okay. It should be further noted that defendant has to pay considerable out-of-pocket expenditures in relation to overnight shipping, notary, printing, certified mail, and other miscellaneous research materials and costs incurred while responding to plaintiff's meritless, vexatious claim and without the ability to submit electronically. Yeah. Yeah. You could technically ask for permission to file electronically from the court, but Plaintiff's continuous argument that defendant is not cooperating or not taking this seriously is patently absurd. Is it, though? As originally stated in the previously submitted confidential memorandum, defendant understands the benefit of attending in-person mediation. Do you, though? It's an important tool utilized by the court in order to conserve resources. So now she's explaining why a mediation conference is good. Which she's not wrong, but then why didn't she participate in it? Okay. It's an important tool utilized by the court in order to conserve resources, to find common ground between two parties, and possibly come to a mutually agreed settlement in order to avoid lengthy trial, in order to save everyone time, money, and unnecessary burden. Yeah, that's not a bad summary of why it exists. Right. Okay. All right. Regrettably, defendant maintains that's precisely due to the detrimental, cost-prohibitive, lengthy abuse of the process at the expense of the defendant of the court, to which plaintiff seeks to harass and prolong this process, having no intentions of ever seeking meaningful resolution and mediation. What? No, that's wrong. I've read the documents. I've read the emails. The plaintiff has tried numerous times to get you to participate in the court order processes. They have tried repeatedly. No. Defendant does not have disposable income to arrange for a continual round-trip airfare to travel in a foreign jurisdiction to engage in a 20-minute mediation conference with an undoubtedly hostile and vexatious litigant. I believe it was available by phone. I don't think you're required to attend in person. Yeah. Okay. Plaintiff has repeatedly made known to both defendant and her affiliates that the suit is not for the purpose of seeking monetary relief, premised on any single allegation of defamation or false light. Have they, though? When? When did they do that? Maybe she will tell us. Plaintiff has repeatedly relayed to defendant through several miscellaneous channels over the duration of her lawsuit that she only filed this lawsuit against defendant to legally harass, punish, antagonize, intimidate defendant for entirely unrelated reasons to have to do with her defamation suit. Well, if you have proof of that, that would be really helpful to bring to the court's attention. If you can show that, you're on your way to abusive process. So, can you show that? That'd be great. Plaintiff has insinuated on multiple occasions she will drop her frivolous lawsuit against defendant in exchange for what plaintiff believes, beyond any rationality, that defendant is in possession of secret evidence which could serve plaintiff in future in pursuing yet another never-ending criminal lawsuit against Whitley Goodman and or Dylan Swearington. First of all, I'm not sure what you mean by criminal lawsuit. Second of all, none of those people are you. So I'm not sure why you necessarily care, but okay. To be clear, defendant has no knowledge of any secret insider information having to do with the 2014 death of Christian Andrea Chero, and stated such to the plaintiff innumerable times during defense attempt to seek resolution. Okay. Well, that may very well be true. You may not have access to any secret information. Okay. Plaintiffs' demonstrably vindictive and hostile conduct exhibited toward defendants both online and offline during the entire duration of the claim, including but not certainly not limited to key conference dates outlined in the case management schedule, have served to further and exasperate tensions and exhausted the goodwill of defendant, having irreparably undermined any possibility of engaging in civil, productive, and time-efficient resolution between both parties, both out of court and face-to-face alternative dispute. Again, I'm not sure that face-to-face was ordered. And second of all, it seems like from the written record, at least, plaintiff was trying to go out of their way to talk to you on the phone, and yeah, I don't think that's true. I think she's using the word harass in the sense of I don't like this legal process, which is not quite what it means. Considering all the people plaintiff has recruited online to violently harass and terrorize defendant, incidentally, most of these individuals make up plaintiff's witness list. How do you know that they've recruited people? What are you talking about? Maybe you have evidence. Plaintiffs and affiliates likewise perpetually harassed and terrorized potential witnesses of defendants at such alarming frequency for so long, defendant is limited to page constraints in identifying them all. With that, defendant, on account of her economic constraints, lack of access to reasonable legal counsel, and lastly, a legitimate fear for her physical safety, mental health, and well-being whilst traveling alone to an unknown state to engage with plaintiff, I'm pretty sure it was via phone. Respectfully submitted, Karen Yax. Okay, well, that was an entertaining thing. Let us look at some of the attachments that she thoughtfully provided in this. So this is one of the attachments she provided. This apparently is a UAW FCA Ford General Motors Legal Services Plan Cooperating Attorney Program. Miss Yax, thank you for contacting us to use your UAW FCA Ford General Motors Legal Services Plan benefit. As we recently discussed with you, your legal issue entitles you to a low-cost referral to a cooperating attorney. The plan has contracts with over 700 cooperating attorneys around the country. Cooperating attorneys are not plan employees. They're independently licensed who have agreed to represent plan participants at greatly reduced hours negotiated by the plan. The plan does not supervise the attorneys and is not responsible for their work. At your request, we have a referral. Here's a referral. And then she says she made repeated calls and no response. Well, maybe you should have called them back for another lawyer or another referral or something if you had that much trouble getting in contact with them. But I mean, apparently she had access to some sort of legal referral program that provided her a name. I wonder what she means by repeated calls. Incidentally, did she leave a message? Did you follow up by email? I mean, how hard were you really trying? I wonder. Lawyers can sometimes be busy. You might have to call them more than once or twice. You might have to leave a message. You might have to follow up. You know, a little bit. You think it's twice? It might very well be twice. Yeah. All right. Anyways. All right. So now here's another attachment. This is attachment 2 to the motion we read. Apparently, these are some of the social media posts that are of concern. So this is from, I'm not sure exactly where this is from, some sort of social media somewhere in regards to the murder of Christian Andrea Chio. Sleuth Syndicate, maybe. So here's some social media posts, people talking about the case, it looks like. Ray's attorney, Matt, and Karen were ordered to have a phone call. Karen says the court of Mississippi doesn't have jurisdiction. Pretty sure court's made that decision, yet she's not filed anything regarding it. Karen's also claiming to be afraid to speak with him, like physically afraid to speak with him over the phone. Yeah. And then here's an email, or here's a letter from counsel for Ray to Karen, you know, trying to like get this done August 3rd, you know. We'll discuss, here's the these are federal rules. Here's what we're supposed to do. And then the attorney for Ray says, with respect, I cannot see how talking to me over the phone would make you feel unsafe, considering your residence is nearly 900 miles away. Do you really believe I'll be able to reach my hands through the telephone to inflict upon you some sort of physical calamity? If you truly believe that, then sincerely flatter you think so highly of my capabilities. Cute. So, trying to do their due diligence and trying to get this thing done from Matt Wilson. Some people commenting about it. This is the best letter ever. Matt Wilson says they're flattered. The broad lives in Michigan. This looks like pretty standard social media commentary. I mean, people engaging in fairly typical discussion about it. I mean, I'm not seeing anything that strikes me as, particularly interesting. Well, let's keep scrolling this. We'll keep scrolling this because we're looking for the evidence of, the harassment and the threats and stuff. So we'll keep scrolling this and see what we got. How can she be afraid of anyone? Nothing that gerbil douche does surprises me. I mean, not exactly nice, but it's pretty par for internet threads. I don't know that it constitutes a threat. Now we have some sort of text message exchange. I don't even know where this was. I don't know what this is. I know you were fed things, and honestly, I feel bad that they played you that way. I felt bad when they were doing it. I would read the comments on your live and just want to scream, shut it down at you. Why isn't Ray sue those people? She doesn't have to. And those people may not have committed a tort. And even if they did, it doesn't mean that you're innocent. So, yeah. I have no dice in this game, but that's my one thing I'll hang my hat on. She's a good woman with a huge heart. And the people who you had behind you fed you BS. Where are those people now that you're being sued? And I'm a woman with a good big heart. Okay. If you know that there's a group out there to get Ray, why not offer up that? Offer it up how? She knows this herself. This was going on long before I came along. 7 freaking years. You get what? Tell her who is behind it all. Tell her who you're conversing with. I've got nothing to offer her except the apology you've been offering since June the 5th. I don't know what this is. I don't know what this looks like. Kind of really typical social media affairs, comments. Remember Karen October 18th and you can't attend via Zoom. I don't know the degree to which that's true or not. I just reserved. This is Matt Wilson, the attorney for Ray. I just received word from Ray that apologies and promises by themselves will not be enough. So unless you can make us a better offer, we'll have to go to court for the settlement conference on a date the three of us choose. You claim financial lack. If that's truly the case, we'd like to see your bank statements and tax returns. Or if you have information that could be a substitute for money, either way, make us a better offer. With that being said, my client may be amenable to accepting information in your possession as an offset to any financial demand. For example, Ray just reminded me that you had said to Chris that you had information that would blow the investigation into Christian's death wide open. Oh, so Ray had said that they had secret information at some point, and now maybe they don't. Ray might have been lying about the secret information she had, which wouldn't that be a first? We've never known a YouTube reporter to represent that they have information when they really don't before, have we? Blah, blah, blah. From Matt Wilson, the attorney. Karen, this is a message. Apparently they're doing their discussions via thread on social media, I guess. This is a strange way to do a litigation, but okay. I mean, you got to go to where the person is. So if that's where they are, I guess that's how we're doing this now. Or maybe this is an email. I'm not sure what this is. Anyways, from the attorney, Karen, this is a message I've been instructed to deliver from my client. I'm quoting Ray word for word. Due to your dishonest approach in these settlement negotiations, I'm instructing my with representatives to withdraw all settlement offers. I'll leave it to the jury to determine the judgment your actions deserve, not what you can afford, but what you deserve. At that time, I'll hire an attorney in Michigan and have the ruling of the federal court in Mississippi certified by federal court, and I'll vigorously pursue every dime of judgment. Okay. I mean, yeah. So I'm not interested in settling anymore because you've been jerking us around. I'm going to take this all the way and let a jury decide everyone's fate. And if I get an award, I'm going to have that award certified in your state, and then I'm going to go get the money. Okay. I mean, things seem to have broken down in this conversation, but that's part of the process. So apparently Ray over here is not feeling very amenable and is like, let's go the distance. Okay, fine. So the attorney is like, well, my client says no. And here's a Federal Mail Express. So she said that she had to send things in via mail. And here's his one such example from Karen Yax to the federal court where she did exactly that. All right. And then there's another filing, which I think is the same thing, but it's filed separately for some reason. She filed it twice. So if you're thinking to yourself, oh, I've seen this before. Yeah, but she seemed to have filed it twice. So you can skip all that. Or the court docketed it twice for some reason. I'm not sure. So she either filed it twice or the court docketed it twice. Whatever. Anyways. So that was all from Karen Yax. Now let's hear from Ray. Reply to the motions for sanctions. All right, Ray, what do you got to say? Comes now, Ray, by and through undersigned counsel in response to Karen. In support thereof, plaintiff states as following. On June the 4th of 2021, plaintiff filed suit against defendant for defamation. Defendant filed her answer on June the 24th. She also filed a motion to dismiss for lack of personal jurisdiction, which was denied. I'm not sure if she strictly speaking filed the motion or the court interpreted it that way, but either way, the court did consider the issue. And I think on the standards necessary for the pleading, the initial complaint, yes. For what it's worth, incidentally, because you've preserved the issue for personal jurisdiction, because you could renew the motion at a later time. So like if after some further process or some further discovery or something like it shows that it's not as good, then you could renew the motion. So like, but yeah, the court has made the court has made the determination for the present motion that's in front of us based on the present standards that's in front of us, right? On the initial complaint. Do we have enough personal jurisdiction to get passed for the initial complaint? Sure. Do we have enough personal jurisdiction to get all the way? I don't know, but we have enough to make our like bare bones case, and not doing a really great job fighting it. So, anyways, since then, defendant has been sanctioned for refusal to attend the telephone conference. She also refused to attend a settlement conference as ordered by the court for removing sanctions. This memorandum is a reply. So she didn't attend a hearing for a telephone case management conference, which she was sanctioned. And now we're moving for sanctions for failure to appear at a settlement conference. I'm like, okay. The court has ordered you to talk to each other and talk about settlement, right? And give it your best faith effort, right? You can come out of that being like, nah, because you just might be impassable, but the court's ordering you to try. So you got to try. It might be a very short conference, depending on how far apart you are, but you got to try. You gotta show up and like give it a college go. All right. Although plaintiff understanding of the motion deals only with defendant's contemptuous refusal to obey an order of the court, her Miranda response touches upon various other topics. Plaintiff feels the need to respond to this. That'll be entertaining. To this end, plaintiff will first describe how the complaint states a valid claim pursuant to rule. By the way, just out of raw curiosity, how does my volume level sound? Is it good? Is it too low, too high? No one's been saying anything. I just thought I'd ask because I'm using a different tool. And I thought, I just ask. But how are we liking it? I shouldn't have asked that question because now I'm going to get competing feedback. It's good. It's bad. Too low. Too high. Okay. Anyways, mistakes were made mostly by me. Sounds great. All good on audio. Fantastic. I'm glad to hear that. Great. Okay. Let's see. Okay. To this end, plaintiff will first describe how complaint states a valid claim pursuant to rule. This analysis will identify the factual, non-conclusory allegations that support the definition of defamation per se and defamation by implication. Right. So we need some facts. Again, this is what I will call notice pleading plus. Right. It's not plus much, but what we got to show is we got to show some facts that seem somewhat possible. Well, somewhat possible that together make the overall complaint seem probable. In a very low sense of the word probable, right? What we mean by probable in this sense is more than a mere possibility. That's what we mean by probable. So probable probably means something like 5%, 10%, right? It's not much. But, we got to show it. I'm pretty sure they did, but, fine. So they'll respond to that again too. Next, plaintiff will demonstrate how complaint makes a valid prima facie case for asserting personal jurisdiction. Great. Plaintiff will show the most of the factors delineated by Calder, which is definitely our go-to case. We know Calder all too well because we discussed it so many times with the Toddy case. Calder is definitely one of our touchstones. And Ravel in the Fifth Circuit point conclusively to finding personal jurisdiction. As for the other factors, plaintiff will show defendant has had opportunity to present competent evidence showing these factors favor her, but that she's failed to do so. Yeah. She might be able to get past Calder. Maybe. I mean, it's worth a try. Let me put it to you this way. If I were representing her, I would not feel bad about trying to give a chance that Calder did not apply a try. Right? I think I could make a non-frivolous argument. Now, not frivolous doesn't mean I'm going to win. Right? But as an attorney, of course, I have to zealously represent my client. And I have to make, basically every reasonable argument in furtherance of my client that won't just completely piss off the court. And I can do that. I can make an argument that Calder does not apply here. Or that we haven't met the standard of Calder, more to the point, because Calder, of course, applies because it's a U.S. Supreme Court case. But I can make the case that we haven't met the threshold of Calder. It's probably a losing argument, but it's not a frivolous argument. It's worth a try. So, but not so much. As for other factors, plaintiffs will also show that defendants has had opportunity to present competent evidence showing the factors, but not so much. Because the complaint states a valid claim and because the court has personal jurisdiction, plaintiff will show the court's order compelling defendant come to Mississippi was lawful and binding. So apparently, they did order her to show up for that particular hearing. Perhaps because her prior refusal via phone meant the court was taking more extreme measures. So maybe the court says, the court's like, well, we tried the phone thing and you're not participating, so you got to show up in person. A fortiori, because defendant willfully refused to obey the order, plaintiff will show she should be sanctioned. Finally, plaintiff will show her actions throughout the proceeding have been proper. As such, defendant's arguments should be no excuse for a contemptuous refusal. Plaintiff incorporates by reference the arguments she made in the motion to dismiss. That's a good thing to do. Just like cover your ass moment. It's like, by the way, just everything I said, I'm going to also say again. But, all right. All right, let's go through the factors. Defendant begins the response by discussing the holding in Twombly, which analyzes the specificity requirement of Rule 8a in the context of an antitrust claim. An allegation of parallel conduct, the Twombly court holds, is much like a naked assertion of conspiracy in a Section 1 complaint of the Antitrust Act. It gets the complaint closer to stating a claim without some further factual enhancement. It stops short of the line between possibility and probability. Right? Okay. To do that, we will show we've met a sufficient factual enhancement. So in Mississippi, the claims of defamation are the following. These are the same standards of defamation everywhere. Different states write them slightly differently, but it's all the same, basically. So in Mississippi, the statements are exactly a false and defamatory statement concerning the plaintiff, unprivileged publication to a third party, fault amounting to at least negligence, either actionability of the statement irrespective of special harm or the existence of special harm. In other words, damages. Yeah. A statement is defamatory if it tends to injure one's reputation and thereby exposes them to public hatred, contempt, or ridicule, degrade them in society, lessen them in public esteem, or lower confidence. In other words, it damages your reputation. To prove actionability irrespective of special harm, which is like, the defamation between defamation per se and not per se, right? Special harm is the not per se variety, right? Just normal defamation. Like I actually got to show it hurt me. In defamation per se, I don't have to show it hurt me because I have pleaded damages for the purposes of the pleading, right? I have to show damages. But if I have defamation per se, that element is assumed by a matter of law. Now, the exact amount is not assumed as a matter of law. But to meet the pleading standard, I have to just show any damages at all. So if it's defamation per se, we're like, well, you've proven at least $1. And that's enough to keep you going, right? Or at least $70,000 or more than $70,000 because we're in federal diversity. But you got the point, right? So we have to, okay. Statements must be words impugning the guilt of commission of some criminal offense involving moral turpitude and infamous punishment. Words impugning the want of integrity of capacity, whether mental or pecuniary, in the conduct of the profession. So, yeah, I think the plaintiff has both those. First, the complaint recites statements the defendant made on YouTube. The complaint quotes defendant as she explained how plaintiff has attempted to control the narrative about what happened to her son, Christian. Quote, and I'm going to continue to lay the groundwork and continue to provide proof of things I claim that she has attempted to control the narrative via intimidation, bullying, lies, bribery, getting people drunk, getting young people drunk, etc., etc. Yeah, those are some factual claims. Those are some factual claims that Ray has attempted to control the narrative via intimidation, bullying, lies, bribery, getting people drunk, getting young people drunk. Those are some factual claims that you said on your YouTube channel. So that might be a problem. Plaintiff's averment that defendant made the statement is factual because the jury could use sensory perception to determine what they said. It was said on YouTube. We're fine. Moreover, because the words are clearly designed to degrade plaintiff in the view of the public, the statement is patently defamatory. Likewise, plaintiff alleges that she's not committed bribery. This too is a factual statement. Right. Fair enough. You've said I've done bribery. I say I've not done bribery. We have a dispute of fact. Right? And for the purposes of pleading, we're going to assume all the plaintiff's statements are true. So, whether or not you can prove that, I don't know, but you've made your prima facie case because we're going to assume it's true for the purpose of motion to dismiss. And so there's a factual dispute. At least there's one that's apparent. Again, we might be able to move to dismiss it later at some later stage or move for summary judgment. We may not be able to win the trial, but we have enough to get us past the threshold. This is a factual statement since the jury could hear them denying the claim or hear a defense witness who supports the claim. Yeah, I mean, I don't think we really need to prove it's a factual claim, but okay, it's a factual claim. To the extent we need to prove that a statement like "I've committed bribery," "I've not committed bribery" are factual claims. Okay, we've proven their facts because a jury could hear you say it. Okay. Secondly, the complaint alleges defendant operates an internet webcast with over 17,000 subscribers in which she discusses numerous real crime stories from across the United States. The complaint also alleges that during the webcast, defendant made the statement. Thus, complaint made a factual, non-conclusory allegation that the defendant published the false statements of thousands of people. Since the complaint alleges malice, the statement would not be privileged. Thus, the complaint makes a prima facie case. Third, the complaint alleges defendant acted with malice and that she knew or should have known the statements were false. Pursuant to Rule 9, malice, intent, knowledge, and other conditions of a person's mind may be alleged generally. So, as to that particular respect, you don't need to show specific facts. If you are alleging malice, intent, knowledge, you can just allege it. So, in that particular respect, you can be conclusory in that particular respect because the federal rules say you can be. Therefore, complaint not need to describe a precise basis for these allegations. Thus, they've made sufficient allegation. Yeah, we say it's true. The rules say we can just say it's true. So, yep, that works. Finally, complaint demonstrates actionability irrespective of special harm by showing defendant has accused plaintiff of criminal offenses involving moral turpitude. Defendant has accused plaintiff of committing bribery. Moral turpitude includes bribery. Fair enough. Thus, it's actionable per se. Okay. Now, what this does not show with these particular statements, what this does not show with these respect to these particular statements, is that these particular statements have any special connection to Mississippi. So, these particular statements are statements of fact, right? They might be false, but without a special connection to Mississippi, we're back into without a crystal ball territory, right? We're just back into Calder. We're back into those kinds of things, right? We don't have a tie between these particular statements and Mississippi. But here's the thing. If we have personal jurisdiction for any reason, we have personal jurisdiction for every reason, right? So any personal jurisdiction will be enough, right? And then once the court has personal jurisdiction over you, they can decide other issues. So are these particular statements sufficient for personal jurisdiction? Not the way they're being recited, they're not, right? According to plaintiff, these particular statements she's just making on her podcast. She's just making them on her YouTube, right? And now we're back into without a crystal ball territory, right? We're just doing the same thing without a crystal ball does. We have a YouTube program, we have a podcast, we're making statements. They might be false statements of facts, but we're broadcasting everywhere. We're not doing anything with special connection to Mississippi. So on these particular statements, no personal jurisdiction as it is recited. But we're not necessarily done because if we can find it for any reason, we'll be fine. So, but these particular statements meet the they meet the defamation. So they meet all the elements of defamation, but they don't have a personal jurisdiction tie on their own terms. All right, so let's keep reading. The complaint states a complaint for defamation by implication. In Journal Publication versus McCulloch, the Supreme Court of Mississippi adopted the reasoning of the Ninth Circuit Court of Appeals, which it can do. The state of Mississippi is free to consider any authority it likes, and it wants to consider the Ninth Circuit, to which Mississippi is not a member, but it doesn't matter because Mississippi can do whatever the hell it wants. There, an attorney for former Church of Scientology members made a speech in which he implied, but not to say, this church tried to sabotage his plan. The Ninth Circuit has said defamation by implication. We could skip that part. Plaintiff disputes the assertion that her son, Christian, died of self-harm. However, even if defendant statements about Hayes Michael and Christian Andriachero are correct, Andriachio are correct, the implication of these statements and this conduct would be defamatory. That's because in the context of the statements, the common denominator between the two men is plaintiff. Ergo, a jury could find they're implying plaintiff was somehow to blame. Well, again, we have a similar problem, right? The complaint alleges the defendant said, I really do believe that Hayes was treated by an overdose by Ray, and Hayes is now dead with drug overdose. and he was treated by Ray. So she has a son that's dead by self-harm, and she's a patient who's dead by self-harm. So that's accusing Ray of effectively medical malpractice, right? She had a patient that she done wrong by, and that patient is dead, which would go to professional harm. So this statement, again, shows potential defamation because you're alleging, right? You're alleging defamation by implication. But this statement does not have tie to Mississippi, so you can't get personal jurisdiction for that. All right. The complaint also said defendant gave the impression to her audience that plaintiff, who has been a mental health service provider, may have been responsible for the death of her son and another young man. Defendant's comments about Hayes Mitchell were juxtaposed about the false statements about Christian Andrea Chio dying from self-harm about Christians, leaves the false impression the cause of the death. Fair enough. By implication, yes, but still no tie to personal jurisdiction. All right, let's continue on. Thus, the complaint alleged defendant made a false and defamatory statement to her YouTube audience. To her YouTube audience is exactly the problem, because we're then just back into our without a crystal ball analysis and Calder. It's too generalized. It's not enough to get us into Mississippi. So those statements are not enough for personal jurisdiction. All right. So now we have to go and prove jurisdiction. We have to show the jurisdictional tie. Okay, let's do that. Having established plaintiff has stated valid claims, plaintiff will now address the question of personal jurisdiction. When a non-resident defendant presents a motion for dismiss for lack of personal jurisdiction, it's the plaintiff's burden to establish the in personam jurisdiction. Yes, plaintiff must prove jurisdiction. Fair enough. If the motion is decided without evidentiary hearing, the plaintiff needs to only make a prima facie case of jurisdiction, is not required to establish jurisdiction by preponderance. Yes, again, we're not looking for very much at this stage of the proceedings. At this stage of the proceedings, we're not looking for very much, right? But once you can't, you have to make it in the first instance, right? If you don't make the personal jurisdiction argument at the top, you lose it. But if you do make it at the top and you lose, you can renew the objection, right? You can't renew an objection that doesn't exist. So do we have enough to get past go? Well, I don't know yet. But does that necessarily, even if we do, does that mean that we can't fight that later? No, it doesn't mean that. We might be able to renew the objection, right? But let's see if we can make it past our bare minimum standards. Can we make it past our notice plus standard in federal court? By previous order, the court denied the motion to dismiss. The court stated the defendant reserves the right to renew motion with appropriate evidence. What I just said. Thus, the defendant could have presented competent evidence to support a renewed motion. In fact, they could have asked for an evidentiary hearing, but didn't either. Okay, yeah. So yeah, you could have asked for more, but you didn't. On March 22nd, the defendant filed another motion to dismiss, but attached no exhibits. Then the defendant filed a third motion to dismiss, along with requests for relief, including summary judgment. This motion had two exhibits, however, neither bears upon the question of personal jurisdiction. Also, neither exhibit contains sworn statements. Thus, defendant has not provided any competent evidence should the court change the mind concerning personal jurisdiction. Thus, the court finding of the court's personal jurisdiction still stands as it should. Here's why. All right. Let's see what we got. The complaint alleges defendant interviewed Mississippi residents over the telephone about the death of the son, that she conducted in-depth discussions about official investigation files that was prepared by Mississippi law enforcement personnel, and she directed at least one message to the plaintiff personally, stating, "You're not ignoring me, Ray. I'm a force to be reckoned with. I'm a Powerball you never met, someone like me." Okay. Thus, unlike the defamatory article referenced in Revell, the defendant's comments in this case reference the forum state itself and activities of the forum state. I don't think a mere reference is going to do it. What will do it, in my view, what will do it is if you can show that she defamed during the interview with the residents. That would do it. But like, to my mind, you have to show a tie between the defamatory conduct and the state, right? Because this is what the nature of personal jurisdiction is. Personal jurisdiction comes in two flavors, right? It comes in the nature of a general personal jurisdiction or specific personal jurisdiction. So general personal jurisdiction exists in the state in which you're domiciled. It may also exist in other states beyond that, but it for sure exists in the state in which you're domiciled. For example, I live in Texas, so Texas has general personal jurisdiction over me. So like, you can just sue me in Texas, assuming you have other causes of action, right? Personal jurisdiction isn't the problem. And if I had a vacation home, which I certainly don't, but if I did, if I had a vacation home like in Florida and I spend a lot of time there, that might be enough for general jurisdiction in Florida too. Maybe. But if you don't have general personal jurisdiction, you have to show specific personal jurisdiction, which is respect to the specific matter. Which is like, for example, I hit you in that state, would do it, right? I don't otherwise have contacts with the state, but I hit you in the state. So I was in the state at the time. So with respect to that tort, that I have connection to the state or, whatever. So what they've shown is what they've kind of shown them separately. And this is why I think maybe it's attackable. This is one of the reasons I think it's attackable under Caldera. Now they didn't really do a great job of this in the motion to dismiss, but I think it's attackable because what you need to show, to my understanding, is you need to show at least one tort, any of them, any tort. You need to show one tort that has specific ties to Mississippi. And for example, that could be I called someone in Mississippi and I defamed to them. Right? So that would do it because then the tort's occurring in Mississippi. So if you can show that one in Mississippi, you get them all, right? You only have to show them for one. Any one will do, but you have to show them for one. So one of the reasons I think it's attackable is because at least on this, and we could go back to the motion to dismiss, I suppose, and go back to its reading. But one of the reasons it seems attackable is that at least here it doesn't seem like we are tying any specific tort to Mississippi. We're tying. There's no connection between the two. She may have made calls into Mississippi, but it doesn't seem like they're sufficiently connected to any of the torts. So it's attackable, but she's not doing a very good job of attacking it. There's an argument to be had somewhere on the motion to dismiss. She made comments on stream with the Mississippi residents. Someone in chat said she made comments on stream with Mississippi residents. She was interviewing on the call with her on said stream. Yes, I appreciate that, but you have to show a more direct connection. It's not enough to show. It's not enough that I make calls into the state and also separately and independent of that make defamatory statements. There has to be more of a connection between the two. You basically have each half, but not together. You don't have a tie between the two. So like, yeah, she might have called a lot of people in Mississippi, but unless you can show a specific tie to the tort, I don't think you have it. Or at least it's arguable. See, this is a bit conclusory though, sweet one. Yax only did the live with Mississippi residents for the sole purpose of defaming Ray. That's a bit conclusory. You have to show something more. I think you have to show more of a tie between the two. I think it's a little conclusory. Unless you can show that she, during those calls, defamed Ray. If you can show that, you're there. If during the calls to this, what you would like, what would be great is if when she was on the phone with them, she defamed Ray to them when they were in Mississippi, then you're there. But I don't really think it's enough to just do generalized interviews and then separate and apart from that make defamatory statements. I don't think that's enough connection between the two. or at least more to the point, it's attackable. It's attackable, right? Whether it is enough or between the two is going to be more of an analysis. It's attackable. It's defensible. It's a defensible position to say, okay, yeah, I did this and I did this, but there's no connection. I did A and I did B. There's just no connection between A and B. And it's like, well, there's a connection between A and B. Oh, that's conclusory. Prove it, right? So I think it's attackable. You know, not for nothing, guys, but as always, just a reminder, right? As always, I don't take sides except as the law might dictate, right? I don't take any particular position on any of these people. I try to give legal analysis, as always. You're more than welcome to have any opinion of Karen Yax that you like. You're more than welcome to have any opinion of Katie Joy Paulson that you like. I'm not telling you that you have to like these people or not. And if you do like these people, cool. That's fine. But my assessments are always rooted in law. And I'm like, I spot a weakness. I spot a weakness. Here is a weakness in the plaintiff's case. It's attackable. Right? And so me saying, oh, it's attackable is not necessarily saying it's winnable, but it's attackable because they're desperate. They're disparate. And I'm trying to give you good legal analysis. So, bad people have rights too. Just a friendly reminder. Thus, unlike the defamatory article, the defendant made comments in the case referencing the forum state itself and activities of plaintiff in the forum state. Insufficient, in my view. Moreover, unlike defamatory article, defendant's comments of their YouTube audience contain descriptions of plaintiff's forum state activities and drew upon forum state sources. Insufficient. Also, defendant made at least one defamatory statements while Mississippi residents were on the phone with her. That would do it. That's the win. That's the win. That's what you need. There you go. That's what you need. That's a bingo. Defendant made at least one of the defamatory statements while Mississippi residents were on the phone with her. You got it. You got it. You got it. That's what you needed. That's a win. And once you have personal jurisdiction for one reason, you have personal jurisdiction for all reasons. And so, poof. That's a win. Thus, defendants could have foreseen the injurious effects of her intentional force would be seen in Mississippi. In short, most of the factors that bear upon minimum context analysis favor plaintiff's position. Any factor that does not favor plaintiff's position deals with the number of people in Mississippi who comprise audience. That would be a problem for the rest of them. Presumably, defendant would have information. However, she's presented no sworn statements. Also, I don't really think it's relevant what percentage of her audience is in Mississippi or not, because you have to show her intentionality. And there's no reason to suspect, just because I'm talking about something that's specific to Mississippi isn't enough. Just because a lot of people in Mississippi are watching it because I'm talking about a thing in Mississippi. So Mississippi residents are presumably more likely to be interested in it than your average resident. So one would presume that the audience by its nature is more Mississippian than not, but that's not enough in my mind. But that's not enough. But what is enough? What is enough? Defendant made at least one statement while Mississippi residents were on the phone. That does it. You have a specific communication specifically to a person in Mississippi, specifically to them, saying a falsehood. Bingo. That'll do it. So, and you only need one. Oh dear, what happened? Okay, somehow I put my thing off screen for a second. It does only have to be one resident of the state and not multiple to bring jurisdiction. Yes, they were talking about two different things. They went back to or at least that's how I parsed it. When they were talking about multiple residents, I think they were talking back about the concepts about like Calder, when they were talking about, in the case of like the National Enquirer, how many printings it had in how many printings it had, for example. So I think they went back to talking about YouTube in general. But yeah, if you can show one direct thing in there, you're probably there. Amber Heard's now suing her own insurance. That doesn't surprise me at all. That does not surprise me. All right. Following suit in Mississippi is not unfair. The Fifth Circuit lists factors the court must consider when determining if it's fair to assert personal jurisdiction. They are the burden, the forum state's interest, the plaintiff's interest in securing relief, the interest of interstate judicial system, and the shared interests of several states in furthering fundamental social policies. When the court ruled that plaintiff has made a prima facie case in support of personal jurisdiction, the court has stated defendant could renew the motion later with evidence to support. Thus, the defendant could have presented evidence particularizing the burden she wouldn't be incurred, but not so much. For example, defendants lamented about her financial state throughout the entire proceeding, yet she's provided absolutely no affidavits or documents such as tax return, bank statements, Patreon statements, pay stubs to support the claim. Instead, she's made unsubstantiated claims about poverty. Beyond this, it's clear from exhibits that either she or her husband works for Ford Motor Company and is a member of United Auto Workers. The court may take judicial notice of pay scale benefits that UAW workers receive from Ford by ascertaining the most recent collective bargaining agreement. In short, they have personal jurisdictions, directed her comments. She defamed plaintiff while talking to a Mississippi resident who she's interviewing. That's a bingo. That's a bingo. Defendant prevailed to present any evidence that would demonstrate to the contrary. Yep. If she's stateless, does she have the ability to sue? Not in federal court, she doesn't. In state court, she could. So it depends where she's suing, I guess. The plaintiff has no valid reason for disobeying the court's order, therefore sanctions involving default are warranted. Because the complaint is not frivolous, I agree it's not frivolous. And because the court has personal jurisdiction, seems that way, at least on the standards as they're sitting right now, for our get out from square one pace. Can we get from square one to square two standard? Yes. Then sure. The court's text-only order compelling her to come to Mississippi was enforceable. Therefore, we may address the sanctions motion to prove the court is in contempt. Plaintiff has the burden of proving the court orders in fact. The order prescribes or requires conduct. Defendant has performed an act or failed to provide the act in violation of the order. The court ordered defendant to come to the court in person. The order was still in effect. Notwithstanding, defendant did not appear at this hearing as noted by the court's own docket entry. Therefore, plaintiff has met the burden of proof. Now the defendant must assert defendants or mitigating circumstances that might cause the court to withhold. Where legally sufficient defense is asserted, such as defendant's present inability to comply, the burden is on mere production rather than persuasion. However, where a defendant offers mitigation circumstances such as good faith, they may tailor sanctions in light of circumstance. In the response, defendant orders purported defenses or mitigating circumstances, but none should be persuasive. Defendant states she has the inability to come for financial reasons. In her own words, she does not have disposable income to arrange continual round-trip airfare to travel to a foreign jurisdiction to engage in a 20-minute mediation conference with an undoubtedly hostile and vexatious litigant, which will inevitably result in a fruitless outcome. However, as stated above, defendant has offered nothing to support the contention of poverty, even though she mailed her original motion dismissed from Hawaii. Nice little burn. There's a footnote here. Granted, she claims she went to Hawaii because her mother-in-law paid for the trip. Even so, that would imply that at least one person in her family has means to subsidize her travel. Plus, someone in the family makes union wages at Ford Motor, so her poverty is very much in doubt. Fair. Beyond this, defendant contends settlement conference would have been futile since, as she put it, plaintiff is undoubtedly hostile and vexatious. However, What defendant fails to realize is the requirement of the rules are binding not only upon her, but plaintiff. In other words, if defendant had traveled 1,000 miles, incurring great expense and troubled process, only for the plaintiff to behave vexatiously, then the court could have sanctioned plaintiff for bad faith, even to the point of dismissing the complaint. Right. Exactly so, right? You are required to give it a try. The court has ordered you to try. And so if she travels 1,000 miles to see you, and they're like, screw you, we're not settling, blah, blah, blah. Like, we're not doing this. And like, you can go to court and be like, Your Honor, I showed up and I was ready to participate, and they kicked my ass out of office right away. They didn't even offer me a coffee, man. Come on, man. And if that's true, yeah, the court can sanction you, including by dismissing your complaint, right? Default does work both ways. Default does work both ways. The defendant can default, so can plaintiff. Yeah, the plaintiff can default too. The court can smack your ass around in the right circumstance. So, yeah. Given the defendant would travel, the court naturally would have held plaintiff to an exceptionally high standard of cooperation and reasonableness. If, for example, plaintiff had taken her proverbial marbles and gone home without making a reasonable attempt to compromise, plaintiff would be severely sanctioned for wasting defendant's time. Thus, plaintiff would have felt more pressure to settle than defendant. It's probably true to some degree. Put simply, the settlement conference was the best way for defendant to walk away from the matter without having judgment entered. However, by refusing to comply, defendant missed a golden opportunity. Sadly, she knows it too. And then they quote her, the defendant themselves speaking, by saying defendant understands the benefits of attending the in-person mediation. Nevertheless, she refused to obey, and she's presented no valid excuse. Plaintiff has acted properly and in good faith. Defendant has made various other claims, including the following. Plaintiff has insinuated on multiple occasions she'll drop the frivolous lawsuit against defendant in exchange for what plaintiff believes. Beyond any rationality, defendant is in possession of secret evidence which would serve the plaintiff in the future in pursuing yet another never-ending criminal lawsuit against Whitley Goodman and Dylan Swearington. Presumably, defendant thinks this is a valid excuse for disobeying the order. It's not. I concur. I concur. That is not a valid reason. At the outset, plaintiff objects to defendant's attempt to introduce evidence of Rule 408 settlement negotiations. Without waiving this objection, we'll state the following. So yeah, settlement negotiations are secret, and they're privileged, and they are. And what is said in there, what's said in there stays in there. What happens in Vegas stays in Vegas, except actually. So maybe we should start calling settlement conferences Vegas. Because what happens in Vegas stays in Vegas. Yes, actually, for real. For reals. They're protected. Yeah. Okay. Defendant declared on YouTube the plaintiff had committed bribery to advance her narrative about what happened to her son. Defendant also implied the plaintiff had caused or contributed to the death of Christian and another man, Hayes Michaels. She said statements along those lines that could be read that way. Yes. And those statements may very well not have sufficient tie to Mississippi for personal jurisdiction, but as I said, you only need one, and it looks like we have one. So, truth is a complete defense to libel. Further, plaintiff has the burden of proving falsity. Since defendant asserted truth as an affirmative defense, if the matter goes to trial, plaintiff will have to prove she did not commit bribery or contribute to the deaths of other men. Fair enough. Plaintiff also contends defendant acted with reckless disregard for truth. Because reckless disregard employs a subjective standard, plaintiff needs to review all communications defendant had with anyone in the investigation to determine good faith. Fair enough. If she had reasons to say those things, if she had reasons to say those things, that might very well get her past negligence or actual malice, as the case may be. Ray is not a public figure, but her son and death and public, maybe that's limited purpose. It's a matter of public concern. I mean, it is a murder, and murder, it's a little bit hard to be much more a matter of public concern than murders. And Ray is alleging murder. So she is elevating it into a matter of public concern. So actual malice may very well be the standard. So yes, so Karen Yaks may be able to win in the end, right? We haven't gone that far, right? Again, we've only tried to assess it as far as we've got it. We've only tried to assess it based on a prima facie. Can we get out the door? Yeah, we have it out the door. Can they win? I don't know. To the extent that Karen Yaks has specific statements from sources, for example, in Mississippi that would allow her to make those claims, she might be protected. Or perhaps a better way of thinking about it is that Ray can't meet her burden. This is possible. The same thing is possible, for example, in the 7M lawsuit, although I have my severe doubts with regards to 7M versus Katie Joy Paulson. I have my severe doubts that Katie Joy is going to be able to meet her burden with respect to 7M and Robert Shin, as we've discussed. But, like in principle, if she's got it, maybe. So maybe she can make it. Maybe she can make it past the motion to dismiss. Or more to the point, a motion for summary judgment. Maybe this doesn't go to trial. Maybe she can win. I don't know. We don't know what the parties know. We don't know what Karen knows. So, maybe. You kind of hope for her sake she has it, right? To the 258 of you who are currently watching, by the way, thank you very much for being here as part of the Uncivil family. I hope you are enjoying this stream as we go through and try to catch up on this stuff and actually do some legal analysis here of the respective positions of their parties and try to look a little bit into the future about where things might be going. I'm having fun. I hope you're having fun. And incidentally, for those of you in the United States, happy Thanksgiving. I hope that you will be celebrating with ones that you care about. And if not, call them. Call friends and family and wish them happy Thanksgiving. All right. Anyways, so yeah. On May the 9th, Plaintiff proposed requests for production of documents. Despite having renewed these requests, defendant did not provide it. That's a problem. Plaintiff notes the suggestions raised by our attorney to defendant were made after plaintiff had propounded her request. Thus, defendant was already obligated to provide it since it bore directly on critical elements. Fair. Plaintiff could have filed a motion to compel. However, in view of defendant's history of obstinately refusing to obey the court's orders, defendant likely would disregard the court's order if such a motion was granted. After all, she once refused to come to a telephonic conference because she was scared. More recently, she refused to attend a court-ordered settlement conference after being specifically ordered. So in good faith, plaintiff suggested that defendant could provide essentially the same information as part of a broader settlement package. Although the information would no longer be needed for trial if settlement was reached, plaintiff believed that such information, if it did exist, had value that might bring her closure into finding out what happened. Fair. So to the extent that Karen does have secret information that would be a basis for her to get past the legal standards, then, it might bring some peace to Ray to know that. That's fair. Regardless, plaintiff had the right to sue defendant for malicious, false, and defamatory conduct. Defendant publicly taunted a grieving mother whose son had died a most violent death. Yeah, okay. Just not for nothing. Not for nothing. But this sentence here is like just purely emotional, right? This does not really bear on the legal analysis. For better or worse, you have the right to basically have negative opinions and say mean things. Now, I don't really think it's really a great idea to go around in your life and berate people whose child has died. That seems like a very bad course of action. But unless you reach negligent infliction of emotional distress or intentional infliction of emotional distress territory, which, is kind of hard because First Amendment principles, but you're allowed to generally deride a grieving mother. So if defendant did that, does that make them a jerk? Maybe. Does that in any sense make them legally culpable? No. So this sentence is a little bit here to tug at our emotional strings, but we're better than that. we do legal analysis here. Given the grief that plaintiff has suffered, defendant's lies would shock anyone who posed a conscience. Well, yeah. Her actions crossed the line, so the mere fact plaintiff would consider settling for reduced sum plus access to information that was already obligated to give says to plaintiff's character in good faith. Fair enough. Fair enough. Plaintiff was willing to settle. She's willing to exchange a dismissal with prejudice in favor for money and other consideration. Defendant, however, has been only playing games. Now plaintiff respectfully submits they should be sanctioned accordingly. Entry of default judgment is appropriate with sanction when the disobedient party has failed to comply with order because of willfulness, bad faith, or other fault as opposed to inability to comply. Because of willfulness, default. We're heading in that direction rapidly. Whether or not we're there or not is the court's discretion, but we're more likely to get default as things go on, right? Default is an extreme remedy. We discussed this, for example, in the Alex Jones case to some degree. Went through some of the court's reasoning on the default, and it looks like reasonable. But default's an extreme remedy. Default's not your first remedy. Default's a remedy that you do for repeated dicking around. And, we're heading in that direction if we're not there. So, yeah. It's not great. Conclusion. Defendant has willingly subjected herself to personal jurisdiction. Seems like that way. Authority over a settlement conference. Seems likely. Refusal to come. No valid reason. In litigation, everyone faced constraints. As for defendant's lack of access to reasonable counsel, Mississippi Bar Association has an online directory listing the names of every attorney in the state. Yeah, and if you call them, they might be able to give you a more direct referral. So sure. And regarding any legitimate fear for safety, defendant could have moved the court for prospective injunction to ensure safety, which, there's really no reason to fear your safety, to be honest. Therefore, I'd like default. Yeah, I think that's pretty reasonable. Okay, so what is this thing? Okay, so then we just have some affidavits to we have attachments to basically show some things to show her failure to comply. So these are things that have happened in the past that we're attaching to show failure to comply. So here's a request for interrogatories that we sent. So here's a request that we did for interrogatories. And, here's what we want and space for response and, interrogatories. This is pretty standard shit. Just standard kind of request for production and just show that we actually did that. So fine. What else we got in this thing? Okay, we got some more shit. All right, we got some more shit from Karen now. Karen would like another shot at it. Defendant's response to plaintiff's response. That truth is an element defense. Okay. Karen, what you got for us? On June the 4th, 2021, plaintiff filed a vexatious, meritorious lawsuits against defendant for defamation per se, or on the alternative, false light. No, I don't think it's, no, I don't agree. Plaintiff, a limited purpose public figure. Well, maybe, but it's also a matter of public concern, so I'm not sure it matters either way. And counsel have intentionally and with prior claim knowledge filed malicious suit against defendant and or had knowledge or reason to know plaintiff filed suit against her groundless. Grounds. Defendant filed a motion to dismiss based on two elements: lack of jurisdiction, failure to state a claim, raising truth as an assertion of a claim of defamation. Defendant still waiting on an evidentiary hearing and a ruling on motion for summary judgment. Defendant will show plaintiff's action cannot survive based on elements of defamation in Mississippi. Okay. Bear vague accusations on behalf of plaintiff against defendant alluding to alleged comments made on YouTube is not a factual enhancement. Yes, it is. It is absolutely 100% that. That is a factual enhancement. right? The bare bones would be you have committed defamation. The federal system of notice plus is you have committed defamation. Here's how. In your YouTube video, you said blah. That's a factual enhancement. Yeah. Without having the ability to dispute the content of the alleged recordings or authenticity of the recordings or whole in part. You can dispute that later, but it's enough to make us pass. It's enough to get us there. I mean, it purports to be that. I mean, if you want to say they're not authentic, then, okay, fine. Nevertheless, plaintiff's fact, the plaintiff has attempted to control the narrative about what happened to her son, Andy Achara. And I'm going to lay the groundwork and continue to provide proof of things. I claim she's attempted to control the narrative via intimidation, bullying, lies, bribery, getting people drunk, getting young people drunk, etc., etc. Okay, sell me. Truth is an absolute defense to defamation per se. Sure. Plaintiff did attempt to bribe and solicit false statements from underage witnesses, as supported by supplementary evidence materials attached herein and labeled, for the purpose of compiling unfavorable false testimony against Whitney and Goodman. All right, let's see what you got. So what we're trying to show is that plaintiff did the things that we said plaintiff did. Okay. Recorded phone call between Frank Wagner and Jordan Edward, recorded in 2019 and made public at the same time, wherein Jordan Edward details Andy Achara is bribing her with cash and marijuana for incriminating Whitney Goodman in the death of Ray Andy Achara. Well, hearsay is a problem, because Ray isn't on the call, but it might be a reason to believe it, I guess. Depends on the credibility, but okay. Recorded and published statements, video depiction, recording phone call between Frankie Wagner and Jordan Edwards, published on social media forums several years prior to plaintiff, following a meritorious claim against defendant. I don't know what that means. Affiliates, family members of plaintiff demonstrating awareness of such materials in existence, circulating within public forums 2 years prior to defendant filing meritorious claims. Screenshot text message of plaintiff daughter Alexa to Hunter Thornton regarding offering financial incentive on behalf of Ray to get incriminating statements from Michaela Castleman against Whitney Goodman in the death of Christian Andy Achara, Andrea Chio. Plaintiff's daughter relaying messages to Hunter Thornton from her mother to get Michaela so fucked up she tells us what Whitney told her she'll throw $10,000 your way, but you have to get it on recording. Plaintiff Ray on publicly admitting the following quote: I've done all kinds of things to try to get justice for Christian. I've bluffed people, I've lied to people, I've done all kinds of things just to try to get what happened. Well, I'm not sure that's specific enough to what you accused her of, but okay. And then there's some social media posts, I guess, that go to try to show some of this stuff. We're using random social media posts at this point to try to prove things? I don't know, man. That's it? No, that was not very helpful at all. I'm not sure what those things were supposed to prove. Or who this is sent to. My mother just said if you get Michaela so fucked up, she tells what Whitney told her, she'll throw $10,000 on their way, but you have to get it on recording. Okay, that's interesting. And here's a random FedEx envelope that for some reason is scanned that doesn't show anything. Okay, great. So, again, we've made it sort of past, we've made it past in the initial threshold. For the motion to dismiss. Some of the stuff might be relevant on a motion for summary judgment, but yeah. So, but it's not the most compelling thing I've ever seen in my life. So I think Karen Yanks might be in a bit of trouble. So, Andy Chia. Okay, well, I try. Can you sue for smack talk? No, not really. No. Yeah, I'm not sure why the random FedEx envelope is in the record. I'm not sure what it's intended to prove exactly, but yeah. So those are all the updates in this case. I think what I know is that Karen failed to show up for the telephone conference and failed to show up for the settlement conference, and the court's probably going to be displeased, and has been jerking around a little bit. So I think Karen's on the weaker end of it right now. But I can't tell you what a court's going to do. Andre Chia. What am I drinking? I was drinking some Reds. I was drinking some sort of cherry soda, and I was drinking my breakfast that I make. But this is what I was drinking. So that's an interesting update. So I hope you enjoyed all that. I did too. So what else is happening in the news? Am I okay? Secret McSquirrel asks if I'm okay. I suppose. Secret McSquirrel, thank you for asking, I guess. Allergies, maybe. What else is happening in the news that's interesting? I noticed that Elon Musk unbanned everybody from Twitter. Basically, that was pretty hilarious and welcomed. Welcome back, Nick and Sargon of Akkad. Glad that you're back. Let's see. There was this one. Thoughts on Shaquilla Robinson? What will happen to Mexico does not extradite and charge the friends who killed her? I don't know anything about the specific situation. Extradition is governed by treaty. So, and Mexico extradites all the time. So I don't think there's going to be a particular problem. Don't read that out loud. Don't read what out loud. I'm not sure about this font. Well, let's play with these different fonts and see what we got. That's pretty good. That one I like. I'll just go with Open Sans. Previous comment? Oh, okay. Andre Keo. I try. Four students who were killed recently. Yeah, that's really, really depressing. All right, I guess I'll sign off for today. Do I know anything about the Delphi case? No, I'm not familiar with the Delphi case. Oh, thank you very much for the super chat. Capitan. A Capitan. Okay, fair enough. Thank you. A Capitan, I appreciate your super chat. Oh, yes, the Jack Daniels versus Bad Spaniel thing going to the U.S. Supreme Court. Yeah, that's pretty cool. And the trademark infringement. The U.S. Supreme Court's agreed to hear that case. So that's a good one. Bad Spaniel made a plushie that looks kind of like a Jack Daniels bottle with some alterations to the labeling of the bottle. So it makes it more like a parody. And the Supreme Court's agreed to hear on this trademark case. This should be a fun one to listen to. That should be a fun one to listen to. I think Bad Spaniel's probably in there, right? But the U.S. Supreme Court has the case is brilliant. We could read the petitions for cert. That might be fun. I wish the Supreme Court would hear that onion case. Me too. I hope they will. Kind of, it almost looks exactly like the bottle. Okay, well, fair enough. Is it infringement or dilution? I'm not sure exactly what the legal theory is. 100%. All right, I'm going to sign off for now. My eyes look a bit red. It's allergies. It's allergies. Allergies, allergies. All right, I'm going to sign off for now. If you've enjoyed the stream, remember to do all the YouTube things, like, comment, subscribe, all that good stuff. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.